Well, thank you, Chief Justice George, for that introduction. I must say, to be a warm-up act for Chief Justice George is quite a responsibility. As he pointed out, we have intersected in our lives and careers over a long period of time as neighbors and in the other ways in which he mentioned. But there is no question that in terms of remarkability, his career outshines that of virtually any other jurist in the United States. After all, he was responsible for managing what is undoubtedly the largest judicial institution in the world, the California Judiciary. And in addition to serving as a justice of the Supreme Court and having the responsibility of running the calendar and running the conferences of that court, he had all of the responsibilities of managing that remarkably complex and difficult to manage institution, and he did so splendidly indeed. And of course, he came to it with a background that brought him to all levels of the California judiciary. After graduating from Stanford Law School, he was a deputy attorney general, and at a very young age, arguing cases in the United States Supreme Court, and then serving as a municipal court judge, a superior court judge, a member of the Court of Appeal, and finally, of course, on the Supreme Court, and then as Chief Justice. So, in addition to those, he at all levels always garnered admiration and respect. His appointments came from across the political spectrum, and that was because of the recognition of the outstanding job that he did in every phase of his career. So when I was asked to give a talk in his honor or his name, that was an irresistible invitation. Now, he also mentioned another intersection in our lives, and that, of course, is the in re marriage cases, which he authored as a justice of the California Supreme Court. I tend to regard in re marriage's case decision that he rendered as his second best decision. Far and away, the best decision that Ron George ever made was persuading Barbara George to marry him. Now, after the Perry versus, well, now Brown, Perry versus Schwarzenegger case came out, Chief Justice George was kind enough to send me a tear sheet, a magazine cover that had portrayed me as a mosaic character underneath a rainbow flag leading a group of presumably gays and lesbians across the parting seas with a very kind note attached to it. So in that connection too, our lives, our careers, our decisions have intersected. Now, in the last year and a half or so since I've been off the bench, I have been reluctant to speak very much about the decision in the Perry case or any of the issues touching upon it. A good deal of water has gone over the dam in the meantime, and given the subject matter of our discussion this evening, I thought that I could touch on it. To some degree, and seeing Peter Keene in the audience, that is inevitable. Peter was kind enough to invite me to speak to the Commonwealth Club several months ago, and I spoke for 40 minutes or so on changes in the legal profession that I had observed in the 21 years that I served on the bench. There was, in the question and answer period, not a single question about changes in the legal profession. Every single question related to the Proposition 8 case. So in a sense, what I'm doing tonight is throwing in the towel. I'm giving up. And I'm going to speak something about the issues. And it's somewhat timely to do so now because this has been a pretty remarkable few weeks recently. As most of you know, the Second Circuit Court of Appeals handed down a decision in a case called United States versus Windsor, which is said to be the most sweeping case touching on the subject of marriage equality. It was a case that challenged Section 3 of the Defense of Marriage Act, That is the provision of the Defense of Marriage Act which provides that the federal government need not recognize benefits to persons who have been validly married under the laws of a state that recognizes marriage equality. And the Second Circuit, in a decision by Dennis Jacobs, the Chief Judge of the Second Circuit, held that portion of the Defense of Marriage Act unconstitutional. And what is said to be remarkable about that decision is that the Second Circuit applied the intermediate scrutiny test for the equal protection analysis that came, of course, originally from that footnote 4 in the Caroline Products case in 1938, I believe it was, a little acorn out of which a mighty oak of jurisprudence has grown, that has given rise to this 3 levels of scrutiny that we apply in this context: strict scrutiny, intermediate scrutiny, and rational basis. Now, that analysis, and particularly the intermediate scrutiny analysis, was first applied in the gender context by the United States Supreme Court in 1976. It was the first case that determined that statutory or administrative sex-based classifications were subject to intermediate scrutiny. That is not strict scrutiny, because the court said there are, after all, differences, biological and physical differences between the genders, but that those limitations enacted on a gender basis needed to be regarded, had to be analyzed as narrowly as possible, and had to directly address the issue at hand. Now, with that background, there have nonetheless been a number who have analogized the cases that Justice George referred to the movement that we saw going back several decades ago in connection with providing marriage equality to persons of different races. There was, of course, in the United States Supreme Court level, Loving versus Virginia. In California, California being far ahead of the United States Supreme Court, made that decision in Perez versus Sharp, a case that Justice George referred to at great length in the in re marriages cases. But it seems to me, and the decision in the Windsor case reinforces the impression that I have, that there is another analogy which I think may be at least as apt as the analogy to the Loving case and to the Perez versus Sharp case. And this really came home to me pointedly in a rather personal way a few weeks ago when I was in Los Angeles at a memorial court session in honor of the judge for whom I had the great privilege of being a law clerk, Judge Robert Kelleher, who passed away earlier this year at the age of 99, then the oldest serving federal judge in the United States, and an individual who was transformative in my life and career. I was his law clerk in 1971 and 72. At this memorial session, I was asked to speak, as were 2 of his law clerks from the 1980s, both females. And they gave the most wonderful memorial presentation that you could possibly give. It was humorous, it was delightful, it had the right degree of sentiment. It had everything that you would love to hear about yourself if you are lucky enough to come back and hear what people say about you. And I can just imagine Judge Kelleher would have reveled in the comments of these 2 women. And what I found striking is that I remember that in 1971-72, when I was clerking for him, and he was thinking about hiring a new law clerk, we had a discussion about what he was looking for in the law clerks to follow. Judge Kelleher was a traditionalist. He believed in tradition. He thought tradition played a role. He thought tradition was a positive good for the most part. It was quite clear in 1971-72 that there were still not many women in the legal profession. There were, I think, 3 in my law school class at Stanford out of a class of about 150 or 160. But it was also clear at that time that that was about to change. And everybody was talking about it. And Judge Kelleher knew that was about to change. And of course, a few years later, it did change in great numbers when large numbers of women came into the legal profession. Well, Judge Kelleher at the time thought, and we discussed this, he didn't think that he was quite ready for a female law clerk. It just didn't quite seem to fit his view of what a law clerk should be. Now, bear in mind, this was not a misogynist I'm talking about. This was not a man who was closed-minded about things, and certainly not closed-minded about women. He had been very instrumental in advancing the professional tennis career of Billie Jean King and also Arthur Ashe. His wife was one of the great tennis players of the 1930s, 40s, and the early 1950s. He was not a man who resisted strong, opinionated women. In fact, he enjoyed the company of such women, but he wasn't quite ready for the idea of a female law clerk at that particular time. But something obviously changed between 1971 and 72 when he began hiring female law clerks. And I wish he were there to have heard what they had to say and had given me the opportunity to say, now remember, Judge, there was a time when you weren't sure that you were prepared to hire a female law clerk. I don't know exactly what he would have said, but I'm quite sure it would have been a brush off. It would have said, oh, I never really thought that, or something. He would clearly have not recognized what his attitude was once he got his mind around the idea that women lawyers and women law clerks were just the same as men. And we have seen, of course, in our profession and in other walks of life, a tremendous advancement of women in the last 30, 40 years, and the acceptance that in many personal roles in life, gender is much less important than it was once thought to be. And it is this decreasing importance placed on gender identity that has been spearheaded primarily by women's and the women's movement that has made possible the advances in the gay and lesbian community in the years that have followed. And the timing of these events, it seems to me, is really quite remarkable. It was 1972, after all, that a case called Baker versus Nelson came to the United States Supreme Court out of Minnesota, in which a same-sex couple had applied for a marriage license under the laws of that state, which provided that such licenses were to be provided only to a man and a woman. That was challenged. It went up to the Minnesota Supreme Court. The Minnesota Supreme Court, in that decision, said that marriage, after all, is an institution as old as the book of Genesis, and it is an institution only of men and women. When that case got to the United States Supreme Court, as it did, the Supreme Court didn't hear it. There wasn't complete briefing. There was certainly no argument. The Supreme Court essentially brushed it off, finding that it did not raise a substantial federal question. That was 1972. All of the marriage equality cases that have followed, of course, have had to deal with that because a decision by the United States Supreme Court that a case does not present a substantial federal question is deemed to be precedential. It is deemed to establish what the law is until intervening and contrary doctrinal developments, in the words of the Supreme Court.